And yeah, look, legal and compliance aspects of web scraping is always a hot topic. So look, I'd like to welcome back Sanaea Daruwala, our General Counsel and compliance expert, to lead this panel discussion. Over to you, Sanaea.
Thanks, Shane. Is this working? Yeah. Good afternoon, everyone. I'm Sanaea Daruwala. I'm General Counsel at Zyte. And most of you have probably been bored by me in the past, where I've spoken in front of you about compliance. And this year, there have been a lot of changes in the legal landscape. We've had a lot of web scraping cases that have come out, and we've had a lot of AI cases, dozens and dozens of them, in addition to data protection authorities weighing in on web scraping. So there's just been a lot going on. So I decided to bring in some people smarter than me. And so we put together this wonderful panel of legal experts for you. And I'm just going to start by, we're going to quickly introduce them so you can get to know who they are and what they do. And then we will jump into some of the fun legal and compliance topics. So first up, we've got Hope Skibitsky from Emanuel. She's a partner there. Hope, do you want to introduce yourself?
Sure. Is this on?
Maybe not.
There we go.
There you go.
Hello. Okay. Hi, everyone. My name's Hope Skibitsky. I'm a partner at Emanuel, which is a litigation firm based in New York, but we have offices throughout the world. I specialize in web scraping law. I worked on the HiQ versus LinkedIn case, and I advise clients when they get demand letters, when they start up, and they're trying to figure out how to mitigate their legal risk with respect to their data collection. And I'm happy to be here.
Great. Next up, we've got Stacey Brandenburg from Zwilgen.
Yep. Great. Thanks. Nice to see you all. I'm Stacey Brandenburg. I am a shareholder in a law firm based out of DC that focuses on technology and data-related law. And while what I bring to this space comes from a background as a regulator at the Federal Trade Commission, albeit a good number of years ago, I've been advising in this space both acquirers of data on their compliance protocols, and as well as those who are web scraping or collecting data in different forms, such as alternative data types of activities. So looking forward to the conversation.
Great, thanks, Stacey. And last but certainly not least, we've
got... the best for last. Hi, everyone. I'm Don D'Amico, the founder of Glacier. So my company, what we do just very simply is that we help people who are taking data from other people, other orgs, get it in a way where they won't get in trouble. And if you've already got the data, we help you watch it so that if something changes, you won't get in trouble. That's really boiling it down. I guess I used to be a hedge fund lawyer, and then more recently I ran the US office of a data sourcing company. And so I'm really glad to have the opportunity to speak to you today, and wanted to thank Zyte and Sanaea and the panelists for the chance to do that.
Thanks, Don. So before we get started, all four of us up here are lawyers. So we have to give a bit of a disclaimer. We are lawyers. We are not your lawyer. So nothing we can say here should be construed as legal advice in any way. Web scraping it's so diverse. There's so many different legal and compliance topics, so we can never really speak to your particular niche issue. But we are all experts in the area. We are here to give you kind of information and guidance. But again, not your lawyers, so nothing here should be construed as legal advice. With that said, let's jump in. I think to start, let's just sort of lay the groundwork, right? So I'll open this up to whoever wants to start. But when you think about web scraping and you think about web scraping laws, what are the big issues that come to mind for you?
Sure. So I'll start. I mean, what's interesting about web scraping laws, as we all know, it's constantly shifting and changing and developing, as is the focus of both the lawyers and the plaintiffs and the defendants and the courts too. So we used to, I think the big focus used to be, are we dealing with public data and what does that mean? And now we have some clarity on what public versus private means with respect to the law. And I think now the focus has shifted more towards, is scraping any given website problematic from the perspective of a terms of service violation, or like more of a breach of contract theory as opposed to any sort of computer hacking statutory theory, because the courts have largely said, yeah, scraping publicly available data is not a breach of these computer hacking statutes. So those are sort of the first themes that come to my mind: breach of contract, some privacy issues, statutory claims.
Anything to add to that, maybe, Stacey?
Sure. So building on what Hope said, that there are two different ways to think about the scraping risks or considerations. And one is when you're going about the scrape, what kinds of activities might create liability for you? And some of that is what Hope mentioned. And the second part is once you have the data, if you're going to sell it, license it, provide it to somebody else, or use it for yourself, what risks might come there? And so on the second piece, that's where some of the copyright issues can come up. It can also be a terms of service violation, a breach of contract if you're misusing the data based upon whatever terms you received it under. And there's always, and we'll talk about this more later, I think, but if you are collecting personal information, particularly in the EU, that can raise a whole other set of issues. So there are a number of different prongs on which to think about, but positioning yourself in the process first will be, I think, an important piece to understand what your risks are and how to help to mitigate them.
There's nothing really to add. I think that was perfect. But I guess I would just say that, you know, the trend in the U.S. certainly has been that this is now like a simpler, more commercial contract issue, like Hope said. But it's very helpful to ground scraping and the practical sort of like, who are you, what are you scraping, and where are you scraping it from? Because so many parties have vested interests in that are anti-scraping, and some just as many as are pro-scraping. And to think about, like, you know, I'm collecting this type of thing. Like, is it a picture? Is it a profile? Is it a field out of a profile from this type of site operator? You know, if you're taking from Meta or Instagram or LinkedIn, that's just a much different set of circumstance than scraping from, you know, a public database that you know, is not run for profit with huge legal teams defending it and has all kinds of interests in a walled garden. So I think in this conversation, it's really important that we kind of like ground what we're talking about, because a lot of us will kind of, our eyes will glaze over and we'll think like, is it okay or not? Just tell me. And that's not always helpful to you, I think.
Yeah, that's great. You all kind of mentioned one point that I think has come up a ton in the case law that we've seen over the last year, which is terms of service and breach of contract. And one of the big things we get from people is, do I need to read the terms of service? Do I need to abide by them? And there's this whole concept in the law of browse wrap versus click wrap. Maybe one of you could explain, you know, what is the difference between browse wrap and click wrap, you know, just definition wise, but also from a legal perspective?
Sure, I can start with this. So when you have a claim for breach of contract, if someone says we had a contract and you breached it, the first question that the court is going to resolve is, well, was there even a contract, right? If there's not a contract, you can't have breached the contract. And so as regards terms of service, the question is, did I realize that I entered into a contract? Okay, so there's the click wrap agreement that you actually have to click on. And then there's a browse wrap agreement that's oftentimes like a little language at the bottom of the screen. Courts generally find that someone has knowledge that they have bound themselves to a contract if they click on it. So from the law's perspective, if you are clicking into an agreement, it is more likely that it is going to be the case that you are found to have been aware that you are bound to this agreement. Browse wrap agreements are generally held to not assume that somebody who has visited a page is aware of the terms of that agreement, and therefore it may not apply to them.
Great. And maybe from a legal perspective, like, what's the distinction there? So can I, for example, if I agree to some browse wrap terms, well, you know, theoretically agree because you're not actually agreeing, are the courts saying, okay, that's not a contract? Is that the result of it?
Right. So simply visiting a page that has its terms of service in the footer and taking no other action, courts have generally found or are generally finding that that's not enforceable. Now, there's nothing that says that if you took other steps, you viewed the terms separately, you created an account in another way, or did something else, that a court might not say, okay, well, you visited that page, you didn't click on an I agree when you visited the page, but there is some other evidence that you knew the terms were there, you viewed the terms, and we're going to infer or conclude that you had knowledge of and therefore entered into a contract. And so what we've been seeing lately is that many of the cases that have been brought, the courts are saying there's not enough evidence here that you entered into that contract. And that's some of what came up in the Bright Data cases that we've all heard about. But that doesn't mean that every situation is always going to be that way just because you don't enter into an agreement when you visit a page. We just want to distinguish that piece of it.
That's really good, Stacey. It kind of leads me into sort of my next question, which is about these cases that we've seen, right? There were these two cases, one brought by X and one brought by Meta against Bright Data. And a lot of you probably saw these cases, and both of them were dismissed by the court for various different reasons. And the big causes of action there was breach of contract. So it related to the terms of service. In these situations, it was publicly available data. They weren't scraping behind the login. But the court dismissed the cases, both cases, for two different reasons. And what we saw in the headlines, though, was web scraping's legal now. You can't, you're not going to breach browser app terms of service ever. And that's actually not what the court said. So I'd love for you guys to give a little bit more color to, maybe Dawn and Stacey, you could take the X case, and Hope, you could take the Meta case, and give us a little more color on what the court actually said. Why did they dismiss it? Why did they say, actually, Bright Data, you didn't breach this contract?
Yeah, so I will let Stacey trace the more complicated sort of like factual aspects of the Bright Data case, but to summarize it, it's sort of that if you're litigating one of these questions, you actually have to be able to produce evidence of everything that you're saying, and that your evidence tracks all of the things that you're claiming the other person did and should not have done. So you've got to be able to produce a log that says, oh, look, their employee clicked on this thing, they did this at this date and time, they clearly read this document, and then they did something else that we also have proof of. And if you can't prove all of the elements that lead to forming a contract, where the contract, by the way, why do we care about contract? It's like because all these contracts say you can't do this, right? They all say no automated data collection. If you can't prove those things, then you're not going to win the case. I want to just kind of create more of a preface to what I think Stacey will say in responding to Sanaea's question or comment about people just saying, one case says scraping is legal, one case says it's not, and we just walk away with this binary response. I was thinking this morning, let's just try this really stupid analogy. It's a little bit like if you said, is it okay to drive a car? Does your car have a license plate on it? Did you tint the windows so I can't see who you are? Are you driving your car on a public highway, or did you drive your car into this private driveway and leave it at your neighbor's house? There's certain times when driving is okay and certain times when it's not. And, it's like the fact that Justin Timberlake didn't get a DUI for drinking in the Hamptons doesn't mean that driving under all conditions is suddenly legal, right? So we don't take a binary reaction or determination from any of these cases. The more defined by contract they are, the more particular to the contracts and the parties they're going to be.
That's a good point. Thanks, Dawn.
That's a great point. Yeah, so I'm not sure there's that much more to add specifically on the facts for the X case, other than to note that the court focused on, there were a number of allegations that were brought, and these are things just to keep in mind, because even though they didn't succeed in that case, it doesn't mean that if you are scraping a site, that a platform or target site that you're scraping may not come back and try these again. And one of them, the ones that I found interesting and I think could still at some point succeed, is this idea of tortious interference, that the impact of a scrape, if done not politely, on a site could cause enough harm to that site. And there are a number of different ways this could play out, and I think some of these things were alluded to in panels earlier today, whether you are triggering ads that then cause harm to the site or cause the site to have to pay for ads that are displayed, or the effect of responding to or trying to refute bot activity causes a site to spin up more servers and have to really expend resources and cause them real monetary harm. Those were some of the claims that were made in some of the cases, and X brought a whole bunch of cases around the same time, including the one against Bright Data. The courts didn't spend a lot of time with the tortious interference in particular, but I think it's one just to keep in mind, and to the extent you need to remind yourself or explain to anybody who is helping to fund your activities why you scrape politely. These are some good reasons why. As for specifically one of the reasons the court dismissed the Bright Data X suit really dealt with the public nature of the data and the fact that what was being scraped was deemed to be available to the public. And so the court didn't think that, just reinforce this idea that information that is available to the general public, you can access it, and that won't be enough to breach the terms of service. So.
And I think a good takeaway from that is, people are, if you're thinking about scraping behind a login, this case would have looked very different outcome. So you want to be mindful of that. If you are clicking to agree to those terms, all of these cases would have a completely different result. So it's nice to see that the courts are actually supporting the idea that publicly available data, we kind of want people to use it in a responsible way. And then maybe a little on the Meta case, because the court looked really closely at the terms of service in the Meta case. Like they really went through them with a fine-tooth comb. And so I'd love to hear a bit of your thoughts on what they found there.
Sure. So in the Meta case, Meta sued Bright Data because Bright Data was scraping publicly available data. And so the question is, Bright Data's defense was, I wasn't bound by that contract because I had terminated all of my accounts with Meta, so I wasn't bound. But also, the contract, if you read it really closely, although it says you can't scrape, it doesn't mention anything about when you're logged out. And so Bright Data's argument was, if I'm not logged in, the terms of service don't apply to me. And so the court looked very closely at the language and said, oh, wait, that's actually the case because it says that it applies to users. And you can't be a user under this specific agreement if you don't have an account and you're not logged in. So this decision happened after the parties had exchanged discovery. So the court also mentioned the fact that Meta had changed its terms of service. And the court scrutinized the difference between the contract as it existed at some point in time and another point in time and said they actually took out the word access, you cannot access, and that might have made a difference in the case. So that's important. I think what's the key takeaway there is, again, what we've all been saying is everything is really fact specific, right? So there, the issue, was not only what did the contract say, but it was what was the history of the contract over time. And I think and it was significant to the court that that Bright Data had terminated its agreements with Meta. So that's again, significant.
And so the court looked at the terms and they kind of parsed it for the language and they said, okay, it actually doesn't apply when you're not logged in. It doesn't apply, to the public data. What if Meta changes its terms and specifically says this applies even when you're not logged in to any publicly available data? Do you think the result would be different?
I don't know the answer to that, of course.
I know, it's theoretical.
But I think it depends in large part on, again, what sort of data you are scraping, and frankly, whether you have the same judge or whether you're in the same circuit. Because, in the U.S., not every court has to make decisions based on what other courts have said. So this Meta versus Bright Data case was in the Northern District of California because Meta's terms of service say California law applies. But it very well, I don't know because this is a whole complicated thing, but it could potentially sue in another state, in another circuit. And that circuit might feel differently about the terms of service. So it really depends, but it's definitely something to be mindful of.
Great, thanks. So, I think the nice takeaway here is it does look like the courts are trying really hard to lean towards browse wrap terms not being enforceable and, public data, not producing a breach of contract result, which is really nice for what most of us do in this room. I think the next big thing that we always talk about, and one of the things I always hear, and Stacey, I'd really like to hear your opinion on this because you do a lot with data protection, is what about if we want to scrape personal data? A lot of people do want to scrape personal data. If we're talking about just publicly available personal data, there's there's a lot of people who just go, oh, you know, none of the data protection laws apply as long as it's publicly available personal data. And what do you think about that statement?
Sure. So like all good lawyers, everything needs to be caveated. In the U.S., under the current state of state privacy laws, there is no federal privacy law yet, and certainly not one that would apply here. But under the state laws, if you scrape publicly available data, and by publicly available, I mean something that a consumer has made themselves available, so not going to the dark web, not taking a data breach, dump somewhere, but something that I've posted. If you go and scrape my publicly available data, there is no additional obligation or restriction on doing that. There may be restrictions on what you can do with the data once you collect it. For example, if you were to collect my cell phone and then text me, you could become in violation of the TCPA or something of that sort. Same for email addresses. So there may be other laws if you use the data in a certain way, but the collection of it in the US is fairly low risk because there are no laws that say, there briefly was, California briefly, but that was amended, just in case some of you have heard that you can't scrape personal data in California.
They added the exception, right?
Right.
Yeah.
They carved that out when they revised the California state privacy law. Now, the big caveat is that this is not the case at all in the EU, and there have been multiple enforcement actions, and the Dutch regulators even came out with a statement that said scraping explicitly is not permitted under the GDPR of personal, they call it personal data. I know many of you are from Europe, but personal data. And so it's a much higher risk now if you're going to scrape personal data in the EU. The other piece is that unlike in the US, where generally speaking, my work email address is not personal data generally in the US. In the EU, that would still count as personal data. So if you're going to go and scrape the contact information for all the lawyers of a law firm or someplace like that, you now could be subject to the GDPR and the obligations that come with that. And Equifax was enforced against in Spain, millions of dollars, or pounds, I think, and then you had to delete the data. So the repercussions here, and that's just one of a number of examples, the repercussions are real. So you just want to put out a big flag if you're going to do that, to really think about how to go about it so that you can comply with the GDPR.
And on the GDPR side, and any one of you who wants to answer it, go ahead. On the GDPR side, there's obviously these higher restrictions, right? It makes no exceptions for public personal data, but it would still apply to you if you were in the US scraping EU data, right?
Correct.
Right. So even though the US has these exceptions, you can still very much be kind of subject to those EU regulations. And we're seeing the data protection authorities look at this more closely with some of the things that you pointed out. So what would your practical advice be? Like, if you're scraping a bunch of data and there's personal data in it, should you go about doing a legitimate interest assessment, or should you anonymize the data? What's the best practical tips that any of you have on this?
So again, it really depends on who you are and what you're scraping and where it is. But I think the practical thing to do is, for a lot of people in this room, you're not thinking like, oh, we're only doing US and we're not looking at the other side of the world. Like, you're kind of scraping from lots of places. You need to build some kind of system that's scalable and usable by people across your organization, whether they're an engineer or some other role, and they can see, like, every time we add a new site to the sites that we collect from, it goes through the same cookie cutter process to be evaluated in terms of, like, where is it? Is there a particular law that applies in this jurisdiction? What are we collecting? And what controls do we need to have? And I think reducing it to, like I said, a cookie cutter process where you're doing something in a scalable and similar way, in a repeatable way, is the key, and not having some, like I said, I think a law firm lawyer approach might be to just have, like, literally a checklist for the things, so that you don't forget. And I think that's a good place to start.
Yeah, so I have a lot of colleagues in the UK, and oftentimes I have GDPR questions, especially when we're collecting data to be produced in discovery. And I'm always surprised at how the GDPR is actually can be tailored to your specific use case. So the answer is not always, so cut and dry. And so I think that the takeaway for that is, and I think the takeaway for any type of regulatory or statutory legislation is to kind of just like take a deep breath before you think that you are necessarily obligated to do X, Y, and Z. Because you might talk to a lawyer who says, oh no, this actually doesn't apply to you for this reason, or actually what you're doing is okay. And I think another sort of practical tip is process is oftentimes really important, meaning have you been thinking about these issues, and do you have processes in place to make sure that you are trying your best to be compliant? So I have found in my practice that if my clients are conscientious about these things, and if they have a checklist, like Dawn mentioned, and or they've asked for legal advice and they're trying to be compliant, that does often go a long way.
Yeah, I think that's a great answer, and that's a really important takeaway. Is it's really hard to be perfect in the context of web scraping laws and data protection laws because they're incredibly complex. They're different globally, right? The US is saying something else to the EU, and they're changing all the time, right? And so it's really, really hard to be perfect. But what regulators do want to see, and what judges want to see, is they want to see that you've made an effort, and they want to see that you've tried. So rather than perfection, I think going for showing good faith effort it goes a really, really long way. So that's a great point. So moving slightly away from the data protection to everybody's new favorite topic, which is AI. There have been more AI cases that have cropped up, particularly in the US this year, than we can even keep up with. It's huge. And we're seeing it against all the big companies, right? OpenAI, Stability AI, Meta, Google. They've all been sued multiple times. And a lot of it has to do with the data that they're pulling into the LLMs, which is often web scrape data, more often than not. So what are copyright seems to be the big issue that's coming up. And I'd love to hear you guys tell us a little bit about what the copyright issues are and maybe how to try to mitigate risk.
Sure. So the copyright claim that's being asserted against some of these big LLM providers or developers is generally, and again, every case has different nuances, but the general claim is you are taking my data and you are producing an output that is infringing on my copyright. And so that's sort of the basic theory. That is just a basic copyright theory. And so everyone's sort of watching what are the courts going to do with these theories. And we don't have much guidance to date because these are a fairly new line of cases. So every copyright lawyer and lawyer who is working in the AI space is following all of these cases.
Yeah, and one of the other pieces that is coming out of this is if you're scraping, are you scraping content that is more easily ascribed with a copyright protection? Not everything that's out there that's published has copyright protections to it. So images something that is creative or has an idea associated with it, or a unique presentation of facts. Facts are not generally copyrightable, so a set of prices is not generally copyrightable. Again, remember all the caveats, and that none of us up here are giving legal advice, but generally your prices are not. Now, if I took the prices and I presented them in a particular way, and there was at least one case that came out of, I think it was either Georgia or Florida, the 11th Circuit, that did say that the entire database of insurance information, that was a trade secret and did have additional protections to it. And so if you want to think about what you're scraping, whether that content is likely to have a copyright protection, and how you might gather it without collecting everything or triggering some of those protections. Again, if you don't reproduce it in a way that mirrors the same presentation, organization, and format, those are the kinds of things that would be more likely to trigger the copyright protection. So it may reduce your risk if you're not taking the data and then reproducing it that way.
Yeah, I guess I would just sort of boil it down to say that, like, in the US, you're safer collecting information than you are collecting content. So a lot of these things that we're talking about, copyright, whatever, they don't protect ideas or a fact about something or a set of information. It's really when you combine these different elements and, you know, you have a profile or you have a series of information that's arranged a certain way. But to collect data in and of itself is often harmless. You know, I think, like Sanaea was saying earlier, one of the really good things for everyone in this room is that the US is very culturally aligned with the concept of, like, information wants to be free and data is sort of open generally. And I think that's the way the case law is also going.
Great. So sticking with the copyright theme for a minute in relation to AI, in these cases, there's kind of two, for a lot of these companies, they're building LLMs, but they have a generative AI system. So there's kind of two copyright inflection points. And one is what web scrapers would be more concerned with. It's, I'm ingesting potentially a bunch of copyrighted data, a picture, an article, something like that, and training my LLM with it. And so is that copyright infringement? And then the other piece is, now we're generating something new based on this model that we trained with potentially copyrighted data, and we're generating something new. Is that new thing protectable? Is that new thing, who owns the copyright to that? Or is that new thing copyright infringement of the original works? We've seen a couple motions to dismiss on that, and so I'd like to get, your take on those.
Sure. So that's always an interesting question. I'm actually going to pass this one off for conflicts purposes, but.
Sure. So there's a world of fair use where certain things can be used to, depending on what protection there is in the data that's being ingested, to build something new. The Copyright Office, and I may be behind on this, but they had at one point issued an opinion where they said unless a human was involved in whatever the thing is that is generated, the copyright protection can't affix. So if it's purely generated by the AI, you can't get a copyright in that. Now, if it was generated by the AI and then a human got involved and did something to it, and please up here correct me if I'm okay, great. Then you have a stronger argument that there may be copyright protection in that. So I think that's where things are right now, at least based upon the Copyright Office's views. Where some of these other cases come out may provide different or other guidance, as Hope was saying. There's a lot of different places we can get guidance on these issues from.
Yeah, there's the famous, like, monkey took a photograph case where it was who owned the copyright, and it turned out nobody, because the monkey's not a human. So the human who owned the camera could not own the copyright, and nor could the monkey. So no one owned the copyright to the photo. And currently what we're seeing with AI, there was actually recently, just in the past couple of weeks, there was a lawsuit brought by an artist who was creating an image through Midjourney. And he prompted for hours and hours and hours and hours. And the Copyright Office still didn't give him the copyright over it. So he's suing the Copyright Office. But now the question is, how much human intervention is needed with a generative AI system in order to have copyright protection? So it's an interesting and still open but very subjective view, because every judge will look at it differently, kind of to your point, in different districts. Any thoughts?
I would just add also that, with copyright, this is a little bit cynical, but the US tendency tends to be to favor big famous parties, and to also look at, some of the stuff that's going on in the courts now. I think there's like a Thomson Reuters Ross intelligence case where you see, one person collecting information, transforming it slightly, trying to create like a slightly different kind of database type AI use case. some of these copyright cases are actually playing out as very conventional in some ways. Like the copyright law is working and it's holding up despite the fact that AI is cool and new. It can be analyzed in a lot of cases. The works can be analyzed as either even not even being works or being works that are subject to typical copyright type outcomes. But I think also practically for the people in this audience, like you would know, if someone hired you to scrape all of the scripts that some other movie studio made and then create a generator for Warner Brothers that makes new scripts, like you can kind of intuit what are the use cases going to be that you should stay away from, that are likely to attract attention. And I think anything where you're clearly competitive with the original creator is much more likely to wind up in court. And I think the artist cases are a little bit like that. I think there's also, though, a strain with the individual artist cases where they're saying, come on, like I had to live in a studio apartment and not go out to dinner for 10 years to produce this painting, and now this robot is just going to copy it, and that seems unfair.
Yeah, no, that's a good point. And those are good practical tips. If you are creating a generative AI system, you want to make sure that what it generates is not substantially similar to what was put in it, because that's where you're going to get into copyright infringement issues. So excellent point there. Now, so kind of to sum up on the copyright cases for AI is they're all still pending. Like we're going to see so much come of this, especially on whether training your LLM with copyright data violates copyright. We actually don't know yet, which is, lawyers hate giving that answer, but we have to right now because all of the cases are still pending. But what we are seeing as well is regulation come out, right? And the US has been a bit slower, but the EU's been a bit more on the ball, and we've got the EU AI Act coming out, and maybe just some general principles coming out of that act that people should be aware of or be thinking about.
Sure. So the EU AI Act, which was passed over the summer but doesn't go into effect, some of it will probably go into effect early next year and then not for another 2 years after that, or to 2026. So we have a little bit of time on it, so take that under advisement. But it focuses first on the level of risk that the use presents. So there are certain high-risk use cases that are going to be much more heavily regulated, and certain things you have to do. And an example of that would be using biometrics or doing something that affects a person and the human dignity so their lifestyle, a little bit like we think about certain things in the U.S. around credit and things like that. I don't know to what extent that's affecting the folks in this room. The next tiers down are more likely to have some impact. If you are there are two key terms. You could be a deployer, which is the person who includes the AI in your service or product. You could be a provider. That's the person who creates the AI. So think OpenAI and anybody who has a chatbot. So those are the two primary roles in which this is likely to come into play. So if your use case for one of those two, and I'm oversimplifying, but for one of those two roles uses AI, then you may need to be transparent about what content you're using to train your model. That's if you're in the general use category. And then also, so it's what you're using to train, and then what you are, when an output has used AI to inform it. So there are kind of two, and again, highly oversimplifying, in part because we don't know exactly what this is all going to look like. It's out there for additional comment and regulations, and there should be more guidance coming. But the sort of boiled down point of it is, if you are engaged in either creating your own AI and putting it out there, or using an AI in your service, you'll want to keep an eye on some of the requirements that may come from the EU. Any other comments?
And are some of the requirements kind of, from what I've seen, some of them are very common sense, and a lot of what was talked about today, when there was a lot of talk about responsibility around AI today, and so some of it was around like transparency. Right. That's a big one in the AI Act, right? If you're if you're building an AI system or using an AI system, if somebody's talking, like if you put in a chatbot, right, on your website, then be transparent that you're not talking to a human being. Those are the kinds of things that the Act wants to see. It is relatively practical in that sense.
Right, and we're seeing the same thing actually in the U.S. too. The Federal Trade Commission has put out statements that if you're particularly consumer-facing, that a consumer should understand if they're interacting with a human or with a bot, those kinds of things, although we've not seen them codified yet, certainly not at the federal level in the United States. The same principles. And if you go back, just to indulge me for a second, all of these concepts go back to the same data protection principles that have been the underpinning of everything we've talked about, from data protection to fairness, how you collect data. It's transparency, reliability, anti-bias or discrimination, all of those kinds of concepts. So if you take the same theories and just kind of apply them to what you're doing and what you're thinking about, you're going to be roughly in the ballpark for where both the U.S. laws and the EU ones are going forward.
Hope, I know we were discussing that there was a potential California law on AI that was going to come out or potentially be signed in, but last week something happened to that, and I'd love for you to give us your take on that.
Sure. So I think most lawyers throughout the country are following what's happening in each of the 50 states with regards to AI regulations, because a lot of states are proposing legislation. Similar in theory to the EU AI Act, but of course every state has different notions of what it wants to regulate. So right now there's one state, and that's Colorado, that has in effect an act. And when I say in effect, I mean that it's been signed into law, but it doesn't actually go into effect for some time. But the California one, I think a lot of people were following. And the California one was based towards making sure that big providers of LLMs, so like complex LLMs, were not presenting an existential crisis to humanity. So what I find when I look at these regulations and when I get news reports about them, I look at the purpose. Because if you look at the purpose, and it's usually like a one paragraph in the proposed legislation, you get a sense of whether this is likely to apply to you. And if the language, like in the California proposed legislation, says something to the effect of, a threat to existential crisis of humanity, and there was a comment about potentially AI creating weapons of mass destruction and cyber attacks that could basically take out a lot of critical devices that we need in this country, you can kind of step back and see what is it that this state is actually focused on, right? And so in California, I think for a lot of folks in this room, the California Act, even if it was enacted, would not apply because the focus was on like big, huge providers. But the governor in California decided he was going to veto it. And he vetoed it because he read, I don't know if he read it, but certainly people, and I read a bunch of the comments that stakeholders were submitting to the government. And a key theme in those comments and a reason that he gave for not signing the bill into law was that it might stifle innovation. And so I think that that's helpful because it's just, Dawn mentioned there being sort of a lot of stakeholders in this space. And that's certainly the case, right? It's not just the government who's deciding what the law should say, but they're listening to stakeholders. And so I find that heartening. And with regards to just the AI regulation generally, I think some key takeaways are, number one, it may or may not apply to you. Some of these AI proposed regulations only apply to businesses with X number of employees, or businesses who are doing business in a given state. And number two, even if it does apply to you, it may not become law. And number three, even if it becomes law, it's probably not going to be effective for at least another year or 2 years or so. So again, just with regards to all of this, I think that a key takeaway is to just sort of not do anything brash when you read about a new AI law or proposed law.
Yeah, that's great. And yeah, I think that for California to come out and say, you know, they've got all the biggest tech companies there, for them to come out and say, we don't want to stifle innovation is big. I think that should give everybody in this room, you know, you should be happy about that, because they're thinking about it in relation to data collection and web scraping and all of that too. They don't want to stifle innovation in any of that, because that all feeds into the AI, which is nice to see. We obviously want protections, but we want them to be reasonable. Kind of a more practical question to round out the AI stuff, and maybe Dawn, you could take this one. Is, you know, we've talked about there's all these laws out there, and there's all this stuff happening, but you know, we're not really sure what they're going to say. We're not really sure whether we're going to come into effect. What are just, if you were, you know, in a company that was using data or selling data to train LLMs, what are some of the just practical policies or you would put in place in your company?
Yeah, I think a lot of it is what people have actually done over the past year, which is to, you know, it's a mix of like surveying employees to figure out what are they actually using, understanding that everyone who has their own laptop or, you know, their phone, whatever, at this point, everyone is using some form of AI tool, even if they're just sort of messing around with it occasionally in some unprofessional way. So permitting and trying to whitelist things that you know are harmless use cases, and then creating some kind of process where people who want to go beyond what is whitelisted or what you think is a safe use case for now have to you know, request some kind of approval or document it in some way. I think those general concepts are kind of the first line of defense for a company. It really, again, it matters a lot depending on sort of what type of tech you're using, what type of company you are, and not, you know, I think like Hope was suggesting, not freaking out that sort of everything applies to you. You probably have lots of, you know, there's been lots of machine learning tools and software that have existed for more than a decade now that, you know, shouldn't suddenly change because AI is a buzzword that's in the spotlight. I think it's things like, I think it's, you know, learning what you're actually doing first and seeing the scope of it, and then trying to decide what's a reasonable place to limit it. But I don't think, you know, obviously every company is going to be under pressure to compete. And the good news is that for now in the US, we're such a pro-business jurisdiction generally that we're very hesitant to regulate things like privacy and AI quickly. And, you know, I think it's kind of what you would have expected, that the EU would have done that first. You know, really all of the tech companies are here. Let's sort of be honest about like the practical. Silicon Valley is in California. It's not anywhere else. And so that's, I think that's going to make it hard for us to pass those kind of sweeping regulations like the California bill.
Thanks. So we could probably talk about this for hours and hours and hours, because there's so many different laws, but we've got a little bit more time, and we've got a lot of questions here, just scrolling through. So maybe let's go to the questions now. Okay, so interesting one. This is pretty specific to the use case. Look, whoever can take it, and look, these are lawyers, guys, so sometimes we just have to say no, and we can't answer a question. So bear with us if that's the case. Sorry, my session keeps timing out, but let me get back here. Okay, so this is, here's a very specific one. It's, can we use YouTube videos meta info, like a description or a title, for ML training? There's probably a very much it depends answer.
It is. One thing I'll say about that, like the first thing that comes to my mind is there's this law called the Digital Millennium Copyright Act, DMCA. And the focus of that is if you're going to take something from some site and you're going to put it somewhere else, and that thing or that image or video is copyright protected, you should include whatever copyright information was in the original post. That's what the DMCA says generally. Beyond that, I'd say, you know, maybe fine, talk to a lawyer about that, but ask them about the DMCA.
So one of the questions is, Stacey mentioned scrape politely, and they just want to know, what does that mean? And it probably means a lot of different things, but give us a summation.
Sure. So I think some of these things may have been alluded to earlier, but when I use that expression, I'm talking about honoring your rate limits, not scraping, spreading out your scrapes, or not scraping at such a volume or at such a time and frequency that you start to burden the site that you're targeting. Being thoughtful about your IPs and how you're using those, again, to try and reduce this is a practical thing too, but the reaction of the site to block, things like that, to just reduce the burden on the target site. This, again, is practical, frankly, because it means you're less likely to be blocked or to catch the attention of the site, but it also, for that same reason, has a more considerate way of going about it.
Great. So we've got a liability question here, which is an interesting one. Is who? Yeah. You guys can also kind of just shout as to who's most comfortable answering the question. So on the matter of liability, is there a transfer of liability when the scraped data is purchased from a provider rather than directly engaging in the scraping?
I think the short answer is that practically lots of people who buy scrape data hope that's the case, and they feel that it might be. I think it's a technical question that's going to be super fact specific, but the problem is that the closer to you and your control that the person who's doing the scraping for you is, the more it looks like you're doing it and they're your agent, and then there's a whole body of law around that. But you could end up being liable as well, just because you put kind of a body between you and the bad activity does not mean that you're sort of totally off the hook. I think also in terms of actual case law, though, it's often more attractive for the party that's been harmed or for a regulator to go after a middleman who's a big distributor versus the end user. And like one individual end user is not a great case if you can get 1,000 end users by going after this, the company that's doing all of the collection. So sometimes it might kind of mitigate some of the risk, but that should not be the reason why you're hiring someone to scrape for you. I think if you're in a position where you're like, we would never scrape this website, but let's get this other company to do it for, that's a red flag. Like, that's not a good...
I agree with everything that Don said, and the agency theory is really interesting and sort of novel in this context because it hasn't really been tested. But one thing I will say is a lot of the statutes that, in particular the anti-computer hacking statutes and some other theories of liability, like there's this ancient theory called trespass to chattels, and that's been asserted against some web scraping companies. And the theory is you've trespassed upon my computer systems by, unauthorized access. So a key element there, and one of the reasons a lot of those claims fail, is because the person that's being sued or the company that's being sued is not technically accessing a computer system. And some of those theories doesn't allow for agency liability. So, for example, the Computer Fraud and Abuse Act, which is sort of like the most famous anti-hacking statute, for the most part, some courts disagree, but most courts won't find agency theory under that statute. So agree with everything that Don said with that, potentially minor exception that that element of actual access can be important.
Yeah, and that's a really good point, because then you are sort of mitigating your liability a bit. But the reality is, and I kind of remind people of this a lot, is anybody can sue anybody for anything. And so it's kind of one of those things. It doesn't mean they're going to win just because they sue you, right? But they can. And so that's just something to be mindful of. But also, to Don's point, which I think is a really good point, like practically, no one wants to sue a small company that's doing something small because they're not going to get anything out of it, right? The only reason that's ever going to happen is if they want to make a point out of you, which is very rare, right? So the risks are kind of low in that regard. I think we've got time for maybe one more question. Okay, Daniel's giving me the look. Okay, so one last one, and we're going to go GDPR with it. when you say EU personal data is protected by GDPR, how to define if something is EU data? Is it based on the location of the website or the person's location or the person's citizenship? How do you know it's EU data?
That's a great question. So the simplest way to think about it would be an EU resident or someone who is in the EU. Those would be kind of the two biggest categories, I think, if you're to simplify it. There may be arguments. There may be other arguments to get more on the fringes, but I think if you stay generally in that space when you're thinking about who you're targeting, again, that would be if the website also, if the company that you're targeting is in Europe as well, even if it's got potentially names of individuals in some other country or jurisdiction. But your activity would still be targeting the website that has... the website would be subject to the GDPR. The individuals about whose data you're collecting may or may not be fully covered. But so let's go back to the first point. The simplest way to think about it, focus on EU residents or people who are in Europe.
So yeah, so basically people living in the EU is really what you want to focus on, and no matter where you are in the world, that's going to apply to you. Yeah. Great. I think that's it. If you have any other questions, feel free to come up to any of us and have a chat.